This presentation is about the benefits of having legal agreements in place before starting a scientific collaboration. Each partner has special techniques and knowledge that they need to share in order to collaborate, but they still want to protect the details from being known to the rest of the community. A confidential disclosure agreement, or CDA, is drafted between the partners. The CDA should be in place before any substantial amount of details is shared, such as molecular structure, how to create specific compounds, how to carry out specific processes. Once the CDA is signed by all parties, detailed discussion can begin. There are lots of exchanges, and the parties come to an agreement on what each team is going to deliver to achieve the project. A contract should be in place to define the aim of the collaboration, the obligation of each party, for example, transfer of compounds or transfer of money, listing the deliverables by each team, the timelines, and what should happen if there are some difficulties during the project. So, what might go wrong if you don't have a CDA or contract in place? In relation to patent, if you don't have a CDA in place, confidential information may get disclosed, which prevents the ability to patent the idea. In relation to publications, for example, some of the information that is necessary to ensure a good experimental design might be disclosed to the general public when it was meant to remain confidential. This might affect the publication. If you don't have a contract in place, the project aim might drift away from the original agreement, losing sight of the deliverables. A partner might want to use the project in ways that were not agreed originally, losing the collaboration aspects of the project or its confidentiality. A partner might not receive the payment they expected in return for the service or collaboration, disagreeing with the original arrangements. Everybody benefits from having agreements in place. Make sure you start the discussion early, as it could be a lengthy process. In the next few slides, I will define some of the clauses present in a contract. A contract should include a summary of activities, a definition of what the activities constitute. Often, there are references to schedules or appendices, where more detailed information about the deliverables and costs are provided. A termination clause defines how both parties can terminate contracts. Also, if some milestones cannot be met, notification in writing might be required. A clause on intellectual property, detailing that the intellectual property which is not available to the public domain remains protected by all parties of the contract. This clause might define who owns new intellectual property generated during the collaboration. A warranty clause is a promise or guarantee from one party to another that the facts are true and reliable. For example, there may be a warranty that the molecule shared during the project is free of pathogen or transmissible diseases. In the case that those facts ever become untrue, the warranty is also a protection to the recipient to cover any losses that may arise. A contract may include a clause on records. It is important to spend time defining the section of the contract on records to avoid any potential issues during the life of the project and beyond. For example, there might be an international collaboration where laboratory records may not be readable by other parties due to the use of languages not common to all parties. Record retention is also important, ensuring that, for example, experimental results remain accessible by the various parties when they need to be consulted, up to the agreed retention time. Also, knowing how long the record should be retained allows each party to put in place adequate storage of records. A contract should include signatures, the name and the title of the person signing and the date. The signature may be electronic. So, when establishing a contract for collaboration, contact your organization administrators or legal department. Most likely, they will have a contract template for you to use.